The Commonwealth has accused Karen Read of striking her boyfriend, Boston police officer John O'Keefe, with her car after a night of drinking and leaving him in the snow to die. The defense is saying, as they said in their opening statement, that Karen Read was framed and this is all a cover-up. We are at the morning break and we are in the middle of the forensic expert for the state regarding Jen McCabe's Google search. We have not heard from other forensic experts. We do not know what the victim's phone was doing, what the defendant's phone was doing, the ME, none of it. But this is the state's expert who is rebutting the defense's expert that we have not heard yet, because she has talked about the conclusion the defense expert made, and she is now talking about her own conclusions. And then the court took a break. So far this morning, this is what we know. There was issues with the jurors early on. At least 4 jurors were questioned at sidebar. 1 juror was dismissed. Court camera feeds were cut, and then the court provided a Zoom link access to the media to use that Zoom access. So this morning, 1 juror was excused after conversation with multiple jurors. The court cut the feeds and then provided Zoom feeds. Court TV cameras are resuming. I imagine that the judge wanted to speak to the producer and to the bailiffs to try to figure out what was going on. The witness testimony, the expert testimony that we were getting into, and I think we got to the end of direct on, concluded that the defense expert made a wrong assumption based on artifacts on Jen McCabe's phone that she searched the "How's long to die in the cold" at 2:27 a.m. and that the 2:27 a.m. time is only regarding to movement of the tab on Safari, and that there was a search regarding Hawkmock Sports or what have you, which is what Jen McCabe testified to. She then said that there was a later search at 6:23 and 6:24 a.m., and those were the 2 searches for "How's long to die in the cold," "How long TDIACKLD." Those 2 searches, we saw them weeks and weeks and weeks ago in a graph. She also said the defense expert concluded improperly that the search was deleted, that the search was not in fact deleted, though that was the way the defense interpreted it, that it was closed, but that information was able to be recovered through forensic tools. So her conclusion is essentially the search on the Safari tab at 2:27 a.m. was relating to sports and there was tab movement. The extraction showed the last known search, which was the searches from 6:23 and 6:24 when it was extracted. And that extraction does not show the time of the search. That is her testimony. We know the defense has another expert, and she used multiple forensic tools to establish that. This witness's testimony is important to the state. I am interested to see the rest of the testimony. I want to know the other forensic data. For me, this case does not hinge on Jen McCabe's Google search. Does it for you? Because there's a lot more we need before we get there. The state finished up with their tech expert who was looking specifically at Jen McCabe's Google searches. The expert was cross-examined very briefly by David Yannetti and said essentially the time 2:27, and that witness had fluctuated in testimony between 2:27 and 2:47. I think it was just misspeaking, but it was never really addressed or clarified, and the defense didn't say much about it. So I don't think anybody in court either caught it or thought it was much of a thing, because on all of the graphs that we could not see, I'm sure it says 2:27, and that time's been pretty clear. But on cross-examination, the answer was really the time that is affixed to that at 2:27 is related to the activity of the tab. That's where that data came from in the extraction of Jen McCabe's phone. And there was a search around then, because the phone was being used at 2:27. There was a search for Hawkmock Sports, and then the search times show searches at 6:33 and 6:34. So this witness was saying you can't correlate the last search in the tab and the 2:27 time. Those things don't go together. They do not directly correlate, and to correlate them is in error. And that's where she said the defense expert has erred in that because the artifact of 227 time goes just to the tab movement. We're going to see a defense expert on this, but that is the state's argument with regard to Jen McCabe's Google search. The state is going to argue, and we heard it in opening, that tab movement happened at 227. Jen McCabe was using her phone at 227, but the search did not happen until 6:33, 6:34 in the morning, and that's consistent with their expert. Then we got into the state's accident reconstruction expert, and we are just going through exhibits where the accident reconstruction expert plotted out on their kind of overview drone shot map where the victim, John O'Keefe's final rest was, which is where they stopped and were found, where other key items of evidence were the shoe, 2 pieces of red plastic, and 1 piece of clear plastic. And those are plotted onto their map. But it seems that is all based on information from Canton PD on February 1st about where they found things. Even though we know that the CERT team is the team that found the shoe and the red plastic in the snow. So some of that has to come from CERT. Some of it came from Canton PD. I imagine the cross-examination is going to rely heavily on, but all of this is told to you by who? Because there was varying degrees of where the victim was. And when you're trying to give a physics-based explanation of how the victim ended up where they did, where they ended up and precisely where they ended up matters, and we don't have that in this case at this point. We have numerous paramedic witnesses who gave varying distances of where the victim was between the road and the flagpole, but you couldn't really get the edge of the road because nobody uncovered it. So there were no very specific measurements on where John O'Keefe was. And we don't have any good video of that. The camera from the police vehicles wasn't pointing that direction, but from the camera of the police vehicles that first arrived on scene, you could see that it was at least within kind of the side purview of that camera. It's really frustrating. We will see how that goes. I imagine cross-examination is not going to go well with this because it's based off of a lot of assumptions, and some of those assumptions might change the outcome. It's just like the retrograde extrapolation testimony. If you are basing the blood alcohol level on a retrograde extrapolation and you're assuming the last drink at X time, in this case, it was like 12:41. If you're assuming last drink at that time and that time's not accurate, it throws off all the other calculations. So the quality of the data coming in is going to impact the quality of the data going out. And isn't that this whole case? Well, Friday, day 25 started out with an extended morning where the court turned off the cameras at one point and a juror was excused. Multiple jurors were questioned. And we are now down to 15 jurors? Only 12 need to deliberate. Then we got through testimony of the accident reconstructionist as we came back after lunch. There are a lot of charts and graphs. It is somewhat difficult testimony to parse, and there are no dates. There are cycles of when the car turned on, but there are no dates. So the Commonwealth, it seems, is trying to connect the incident they believe happened at 34 Fairview to the cycles of when the car turned off and on and when Karen Reed was driving around versus when they were testing the car, showing that the car at one point did reverse up to 24.6 miles an hour. And the expert gave the opinion that the log data from the Lexus SUV was consistent with a pedestrian between a vehicle, with a collision between a vehicle and a pedestrian based on the deceleration of speed, the change in position of the steering wheel, and the fact that the depression on the accelerator was consistent even though there was a deceleration in speed. Those are the bases of his testimony. We have not gotten to cross-examination yet. Towards the end of the day, the Commonwealth started to ask this witness about the ring video footage from when the defendant backed out of the victim's garage and into the victim's vehicle. Then it went on voir dire, which means outside the presence of the jury. Both the Commonwealth and the defense questioned that witness about that video. The Commonwealth is seeking to elicit an opinion from their expert witness that the force and manner of, as he called it, the bump, I call it the bump, the force and the manner of the bump between the victim's car and defendant's car, plus the photos of damage or lack thereof to the victim's car, indicate that the bump between those two cars was not sufficient to cause the damage to the taillight, and that any bump between those cars happened between their bumpers, and there is a scratch on the defendant's bumper, no damage on the victim's car's bumper, and for the taillight to have been damaged, those bumpers would have needed to collapse more. On cross-examination of that voir dire, the defense got into, well, you didn't put the cars together. There's a lot of testing you didn't do, and then got into, when did the Commonwealth ask you to render this opinion? And it seems that it was a couple weeks ago that the Commonwealth had a meeting with this witness to prepare for trial, which is not uncommon. But that's when this witness was asked to render a new opinion as an accident reconstruction specialist. And when he was asked to render a new opinion, that was not memorialized or given to the defense, which is completely inappropriate. So the Commonwealth is trying to elicit a new expert testimony from their accident reconstructionist about the two cars, victims and defendants, and whether that caused the damage. The defense is saying this has absolutely not been disclosed. This is being ambushed. The judge is like, can you all take the hyperbole down, and said it to both the defense and the prosecution. It's not helpful. And the defense said this should have been disclosed, and the Commonwealth agreed. In hindsight, it should have been at the end of their arguments to the court. What does this mean? Well, I think when the judge rules on Monday, this will be kept out because it was not disclosed. I think that is the appropriate ruling to keep this out. It was not disclosed to the defense. I don't think cross-examining on it will be enough. I don't think it will be helpful at this point because, again, if the defense tries to get their expert, who will be voir dired on Tuesday, to rebut it, then that has to be disclosed to the state. Like, the defense hasn't had time to prepare this with a defense accident reconstructionist, and that reconstructionist seems to come from the federal investigation, not hired by the defense. So this has created an absolute mess. The court can choose not allow this witness to testify to that opinion because it wasn't disclosed. The court asked for a bunch more evidence and said that they wanted to review that evidence over the weekend before making a ruling. The evidence isn't going to clear up the issue of the disclosure, though, and I think that that reason alone, you keep it out. Jackson was pissed. And it's interesting enough, this witness said the first time that he saw that ring footage was from court TV sometime before this started trial. These attorneys are not happy, and the cross-examination of this expert is going to be fiery on Monday because this expert was pushing back on most of the things Jackson said. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.